when corporate structure becomes a water liability strategy. In 2015, DuPont spun off a significant portion of its chemical operations into a new publicly traded company called Chemours. Along with the business went a substantial share of DuPont's environmental liabilities, including those tied to PFAS compounds that DuPont had manufactured and discharged for decades at its Washington Works facility along the Ohio River in West Virginia. The legal architecture was deliberate. The separation agreement required Chemours to indemnify DuPont against a defined category of environmental claims. On paper, it was a clean transfer. In practice, it became one of the most closely watched examples of corporate liability structuring in environmental law, and it is still unraveling in ways that should concern every EHS and legal team managing water-related exposure inside a complex organization. What DuPont knew and when, the PFOA contamination that anchors this case did not emerge suddenly. DuPont's internal knowledge of PFOA toxicity and its presence in the drinking water of communities surrounding the Washington Works facility dates to the 1980s. Internal documents produced through subsequent litigation revealed that the company had conducted its own health studies, identified concerning findings, and continued manufacturing and discharging PFOA under regulatory frameworks that did not yet require disclosure of what the company's own science was showing. The public accounting began in 2001, when a West Virginia farmer named Wilbur Tennants sued DuPont over cattle deaths he attributed to contamination near the facility. The litigation that followed, driven by attorney Rob Bilott, eventually produced a class action covering approximately 70,000 residents in Ohio and West Virginia, and a community health study that linked PFOA exposure to 6 diseases, including kidney cancer and testicular cancer. By the time Chemours was spun off in 2015, DuPont had already settled the class action for $671 million and was facing an ongoing docket of individual personal injury cases from plaintiffs identified through the community health study. Those cases were among the liabilities transferred to Chemours under the separation agreement. What followed is instructive. How the separation agreement came apart. Chemours began paying out settlements and legal costs at a rate that the company's balance sheet struggled to absorb. By 2019, Chemours was pushing back, filing suit against DuPont and its spin-off entity Corteva. DuPont had itself split into 3 companies in 2019, arguing that the liability transfer had been structured to offload obligations onto a company without the financial capacity to bear them. The litigation between Chemours, DuPont, and Corteva over who ultimately owned these liabilities ran until 2021, when the 3 companies reached a cost-sharing agreement. Under that arrangement, Chemours retained primary responsibility, but DuPont and Corteva agreed to contribute up to $4 billion collectively to cover PFAS-related costs above a threshold, including future liabilities not yet resolved. In 2023, DuPont, Chemours, and Corteva collectively agreed to pay $1.185 billion to resolve PFAS contamination claims from U.S. public water systems, separate from the 3M settlement. Chemours simultaneously faces ongoing regulatory enforcement in North Carolina related to its Fayetteville Works facility, where Gen X compounds have contaminated the Cape Fear River and the drinking water supply for hundreds of thousands of residents downstream. The liability that DuPont attempted to transfer in 2015 has now followed the corporate structure through 2 reorganizations, one failed indemnification arrangement and a renegotiated cost-sharing framework, and it is still not resolved. What the courts have said about successor liability. The DuPont-Chemours dynamic has broader implications because courts have been consistently skeptical of liability transfers structured primarily to insulate predecessor companies from environmental exposure. Under successor liability doctrine, courts in multiple jurisdictions have held that a company cannot fully divest itself of environmental obligations by transferring them to an entity that lacks the financial capacity to satisfy them. The reasoning is both equitable and practical. Environmental contamination affects third parties who had no role in the corporate transaction and no ability to negotiate for protection. The Resource Conservation and Recovery Act and CERCLA Both contain provisions that regulators and plaintiffs have used to reach back through corporate reorganizations and hold predecessor entities responsible for contamination they caused, regardless of what the spinoff agreement said. EPA has used successor liability theories in Superfund enforcement actions where responsible parties attempted to transfer liability through bankruptcy or corporate restructuring. For legal teams advising on mergers, acquisitions, and spin-offs that involve environmental assets, the DuPont case is now a primary reference point. The question is not whether a liability transfer is legally structured correctly. The question is whether it will hold when regulators and plaintiffs test it. It often doesn't. The EHS dimension that gets missed in boardroom conversations. When corporate development teams structure transactions involving environmental liabilities, the conversation tends to focus on indemnification language, reserve adequacy, and insurance coverage. What often gets less attention is the underlying science and regulatory trajectory. DuPont's separation agreement was structured against a regulatory baseline that has since shifted fundamentally. When Chemours was spun off in 2015, there were no federal enforceable limits for PFOA in drinking water. The EPA health advisory was non-binding. The full scope of community health impacts had not been officially established. 9 years later, EPA has finalized maximum contaminant levels, multiple states have enacted their own stricter standards, and the litigation landscape has been transformed by a body of science that didn't fully exist at the time of the spinoff. Liabilities that were quantifiable in 2015 turned out to be dramatically underquantified because the regulatory and scientific framework they were measured against continued to develop after the transaction closed. This is the dynamic that EHS leaders need to bring explicitly into corporate development conversations. Environmental liability is not a fixed number at the time of a transaction. It is a function of current science, current regulation, and the trajectory of both. What looks like an adequately reserved liability today can look very different after the next round of rulemaking, the next community health study, or the next state to establish enforceable standards. The organizational lesson. The DuPont case is not an argument against corporate reorganization. It is an argument for EHS and legal teams having an honest and technically grounded view of what water-related liabilities actually represent before any restructuring conversation gets finalized. Specifically, 3 questions deserve direct answers before any transaction involving environmental assets closes. Does the receiving entity have the financial capacity to satisfy the liabilities it is absorbing, including liabilities that don't yet exist but are reasonably foreseeable given the regulatory trajectory? If the answer is no, the transfer will face legal challenge and may not hold. Has the liability been assessed against forward-looking regulatory assumptions, not just current standards? PFAS is the clearest current example, but the principle applies to any area where the science is developing and the regulatory response is still forming. What is the predecessor entity's residual exposure if the indemnification fails? DuPont discovered that the answer to this question was not 0. Legal teams that assume a clean break based on contractual indemnification without stress testing that assumption against successor liability doctrine and regulatory trajectory are advising on incomplete information. Water compliance is generating the kind of liability that corporate structures are designed to contain. The DuPont experience shows that containment is harder than it looks, and that the gap between a well-drafted indemnification agreement and actual insulation from liability can be measured in billions of dollars and years of litigation. That gap belongs in the EHS conversation, and it belongs in the boardroom. You've been listening to Sustainability Soundbites by Environment and Energy Leader. For partnership opportunities, please reach out to our team.